G'day everyone. This is the second video in week 3 of our admin law course. In the first video, we got into the time machine and went back hundreds of years to look at certiorari, the ancient writ by which a higher authority reviews the decisions of a lesser authority. In this second video, we're staying back in the past and we're looking at two more writs, Mandamus and Prohibition. Remember that a writ started out as a written command from the king. So we're going to start with mandamus. Mandamus comes from the Latin word mandatum, which means to command. There's a number of English words with the same Latin root that you'll be more familiar with. When something is mandatory, you've been commanded to do it and there's no options. The word command itself contains the echoes of mandatum. If you give someone power to issue commands, you give them a mandate. When someone is held in prison by the court's command, they are on remand. So you can see that while mandamus might look like Latin gobbledygook, it makes sense as a word, and it gives us clues about what mandamus might do. You see, a writ of mandamus says to someone with a duty, you must go and perform your duty. So back in the early centuries of the common law, as we've already discussed, the king and the central government relied on lower level officials on the ground to actually get things done. But what if those officials just decided to kick back and do nothing? Well, in that case, someone who wanted those duties performed could go to the central government and seek a writ of mandamus. It was like a way of saying, hey, this local official is not doing their job. You're the king. Can't you make them? If the king agreed, then a writ of mandamus would go out, directly instructing the non-performing official to do their job. And ignoring a writ of mandamus, as you could imagine, would have even more serious consequences. Let's look at an early example called Curtis's Case, which is 800 years old. Now, one of the most important things that early English law spent a lot of time worrying about was title to land. When King William the Conqueror first set up his system of nobles, he gave each of them control over land. Land produced rents, and land was probably the most valuable thing in the whole kingdom. Disputes about who owns land and what the boundaries are and how the interests of landholders could be protected, they were a very significant feature of those early cases in the common law. Now, if someone died without an heir back then, the land would go back to the crown and the king could give it to someone else to control. All of this was organised by a person with the odd title of Escheator. So the Escheator would identify the land and anyone with an interest in the land, work out what would happen with it, and do it all on behalf of the king. Curtis was a tenant on part of the land when the owner died without an heir. The Escheator, however, took no notice of his tenancy. Curtis didn't want to lose his home and his farm, so he went to the court and obtained a writ of melius inquirendum, which basically required the Escheator to examine his claim in relation to his tenancy. The Escheator didn't. So Curtis went straight back to court and obtained a writ of mandamus, under which the Escheator was specifically commanded to do his duty. The history books don't tell us whether Curtis ended up with his land or not, but I really hope he did. Do you see how it works? Mandamus was an instruction from the central government to a local official saying, you have a duty, go and do it. Another example I can give you is from a case called Cliffsold and Parry. This was a case brought by a squatter whose land was being resumed near Sydney so that the government could build a public school. Now, he went to court and he asked for a writ of mandamus, instructing the Department of Public Instruction, which nowadays we would call the Department of Education, to assess his land value and pay him compensation. They didn't want to do that because they said he was just a squatter and not a landowner. The court, however, said to the public servants, you have a duty. Go and do it. Assess his land value. pay him compensation. Prohibition, as you can probably guess, is the exact opposite of mandamus. So where mandamus says to the public servant, you must do this, prohibition says, stop everything, you must not do this. It can be used to prevent a public servant or an official from going ahead and implementing an unfair decision. To see this in action, let's go back and have a look at a really old family law case called Langleys Case. It's a case from 1572, so it was happening around about the time that William Shakespeare was a child. When Marmaduke Langdale married his wife Joan, and yes, seriously, his parents named him Marmaduke, he took control of all her possessions. She ceased to be a legal person and became kind of a wholly owned subsidiary of her husband. This was a legal doctrine called coverture, and it lasted until the 19th century. Women literally ceased to be people when they got married. Eventually, there was trouble in the Langdale household, and Marmaduke set his wife aside. Back in those days, divorce was next to impossible, but it was very common for people who were reasonably wealthy to effectively end marriages by simply sending their wife away and pretending she no longer existed. However, they were not allowed to simply abandon their responsibilities to their wife. So it was possible for the wife to sue for maintenance. And that's exactly what Joan Langdale did. She sued in the ecclesiastical court, so the church court, by bringing her case before the Bishop of Canterbury. This would have seemed like a logical thing to do because back then marriage was a church matter, not a civil matter. So it would have made sense for the church to also be making decisions about maintenance. The last thing Marmaduke wanted, though, was to find himself standing in front of the bishop to explain why he had set his wife aside. Given the church's attitude to the sanctity of marriage, that was not going to go well for him. And so he countersued, but he sued in a common law court. The first thing he asked was that the common law court take steps to prevent the church court from issuing a judgment. The common law court agreed with Marmaduke that they were the correct court, and so they issued a writ of prohibition, prohibiting the church court from ruling on the case. See how it works? The central authority, the Crown Court, gave an order to the church court saying, you must not proceed. History doesn't record what maintenance Mrs. Marmaduke eventually received, but you can bet it was less generous than she would have received in the church court. A more modern example, and an example from Queensland, comes in the Attorney General of Queensland against Wilkinson, a 1958 case. Back in those days, the idea of Sunday trading was very controversial. The Christian tradition, of course, was that Sunday was the Sabbath and that nobody should work on the Sunday, but instead they should go to church. Church in 1950s Queensland was a big deal. 88% of Queenslanders identified as Christian, and the numbers of church attendance and Sunday school attendance back then was actually growing. So a decision to allow Sunday trading was not just a commercial decision, it had a significant social and cultural context. From this perspective, petrol stations were crucial. The 1950s was the decade that motor vehicle use in Australia took off, and cars went from being a luxury item to being a commonplace means of transport. The FJ Holden, released in 1953, was a big contributor. The concern was that if petrol stations were open on Sundays, then families would choose to travel on Sundays instead of attending church. Service station owners, of course, hoped that that was the case. They went to the Industrial Court of Queensland and sought permission for limited Sunday trading. And they won, because the Industrial Court focused only on the trading aspects of the decision. The decision of the Industrial Court was challenged in the Queensland Supreme Court and then in the High Court. The decision of those courts was that the Industrial Court had gone beyond its powers, beyond its jurisdiction, by making that decision. And as a result, a writ of prohibition was issued to prevent the decision from going ahead. See how it worked? The higher authority decided that the decision was not proper, because the industrial court had gone beyond its powers, and so the higher court issued a writ of prohibition to prevent them going ahead and implementing the decision. Incidentally, Sunday trading remained contentious in Queensland well into the 2000s, and to this day in Queensland, Sunday trading hours are more restricted than on other days. These days, however, that's mostly a matter of penalty rates and workers' conditions, given the massive decline in church attendance. So now we know about the writ of certiorari, under which a court calls for a decision to come before it for review. And we know that after such a review, the court might issue a writ of mandamus, telling the lower authority to carry out a particular duty, or the court might issue a writ of prohibition, telling the lower authority that they must not carry out certain activities. In the next video, we're going to learn about the final two sorts of writ that we'll discuss in this course, the writ of habeas corpus and the writ of quo warranto.